Senator Hall, you're here. You're on the list. Item 8. Senator Hall is SB 1199, item 8. And welcome, Senator. You have the floor.
Thank you. Mr. Chair and Senators, SB 1199 would allow an estimated 95 billboards located in former redevelopment areas to advertise businesses within the redevelopment area's successor agency jurisdiction, mostly the city or county where the billboard is located. In 2013, this body, the legislature, unanimously passed and allowed the governor to sign 684 into law that allowed approximately 95 grandfathered billboards to continue advertising businesses within the original redevelopment area. While SB 684 was an important bill to help local governments, the bill limited advertising to a jurisdiction that no longer existed, redevelopment areas. By allowing these billboards to advertise businesses within the successor agency jurisdiction, mostly a city or city county, these communities will be able to continue to advertise local businesses under their jurisdiction and help local governments pay for public safety and other critical areas. I respectfully ask for your aye vote.
Thank you, Senator. Speakers in favor of the bill, please come forward. Welcome.
Mr. Chairman and members, Jason Gonzalez, we represent a number of former redevelopment agencies, now successor agencies, that are grappling with what to do with the billboards and looking to have this flexibility as part of their long-range property management plan implementation and strong support. Thank you.
Okay, other speakers in favor? Can I have the opposition, please, come forward? Opposition to this bill? Welcome. You have the floor.
Afternoon, Mr. Chairman and members of the committee. I'm Ronald Beals, representing the California State Outdoor Advertising Association. We appreciate the efforts of Senator Hall to maintain a source of income for one of his cities, City of Inglewood. However, we believe this bill is premature and unneeded at this time and would establish a statewide expansion of a federally questionable law and create a legislative fix for two giant signs in one city. A recent decision by the Office of Administrative Law determined that two ultra-sized billboards in the City of Inglewood violated state law. This decision stated that this sign generates over hundreds of thousands of dollars annually for the city and thus the interest of the city. However, a statewide regulatory change is unneeded at this point, as the decision is subject to judicial review, and the administrative laws judge decision made it expressly clear that Caltrans could not take down these signs while these proceedings are continuing. To our knowledge, no other operator or city has requested this relief, and it does not seem to be needed in any area outside of this one particular situation, where it would only be needed if the current administrative law decision is affirmed after probably several years of judicial proceedings. As pointed out in the redevelopment, in the staff analysis, the redevelopment area billboard exceptions violated federal billboard regulations, putting 10% of California's highway trust funds in danger of being withdrawn. Now, admittedly, the feds have taken no action. However, given the lack of transportation funding, should the state expand a questionable program and take the risk of initiating more thorough federal review? CSOAA has been long concerned that the operators have abused redevelopment advertising exceptions to simply place general advertising messages rather than target them to help redevelopment business. We are concerned that this proposal creates an on-level playing field for those outdoor companies that have maintained lawfully permitted billboards. SB 1199 would benefit those who have not complied with existing law while punishing other businesses that have abided by the statute. For these reasons, we urge your no vote.
Yes, sir. Welcome.
Thank you, Mr. Chairman, members of the committee. My name is Ryan Brooks. I am the Senior Vice President of Government Affairs for Outfront Media. Outfront Media is one of the largest media companies here in California who supports many jobs. One of the reasons why we oppose this bill is we don't believe that bad players should be rewarded. When the particular company came into the city of Inglewood, they came in with the intention, and the sole intention, in my opinion, of skirting the law. What they're trying to do today is get around that law. We don't think it's fair as the good players in the industry who follow by the rules, who do what we're supposed to do, who get the proper permits, that should have an end around by creating state legislation that would protect bad behavior. I'm not going to repeat much more with my partner said, but I hope that you vote no and do not reward bad behavior by skirting the law. Thank you.
Okay. Other speakers? Speakers opposed? I see none. Questions? Senator Cannella.
Senator Hall, good afternoon.
Thank you.
So in the staff report, it says that, this is page 3 at the bottom, additionally, the expansion of the exemption would conflict with regulations that are adopted pursuant to the Federal Highway Beautification Act, would place California at risk to lose up to 10% of its federal funds. It's about $350 million. That's a big hit. Do you agree with that
I do
assessment?
not agree with
Okay.
that. It would not put anyone at risk of.
Well, I don't think that you would, but so you disagree with the staff's assessment? Why?
Well, because there are only 95 signs that we're talking about here across the state of California in redevelopment areas that we're supposed to only advertise in redevelopment, businesses in redevelopment areas. And that was the Hill Bill in 2013. Unfortunately, once the redevelopment areas was taken away, the signs could not advertise at all because there's no redevelopment zones. And so it's minimal money right now that these signs are actually making because they can't advertise only things that were in the original redevelopment area. So tens of millions of dollars doesn't even equate to what, comparable to what the signs are actually generating.
So there are existing signs that are not being used?
Minimally, because the way the legislation was written says that you can only advertise businesses in the redevelopment area that were once in the redevelopment area. Well, those businesses are limited. So for instance, if McDonald's wanted to take an advertisement on this billboard and it was not in the RDA area, it couldn't do that. It couldn't do that. It can only advertise from businesses in the redevelopment area. Let's say, for instance, in Compton. If one area of Compton was a redevelopment area, and there was a billboard there, and they said, hey, you can only advertise in, the businesses in the redevelopment area, how much do you think a billboard would cost, and what businesses in Compton would be able to afford to advertise on that billboard? Okay. The problem that and they're mentioning Inglewood, this will represent 95 billboards across the state of California, the same bill that Jerry Hill did, but this basically gives some clarification and some additional help for these billboards to be able to advertise so that they can pay revenue to the city. Absent these billboards being able to advertise, these communities that was already hit by the vacation of the billboard or redevelopment will have to basically cut staff, cut law enforcement services, et cetera. This is a big hit to these communities that already took a hit when they eliminated redevelopment agencies. And this is an unintended consequence of it.
Mr. Chairman, if I may, just another question. So does the city own the billboards?
No, it's
How does it?
different companies.
So the city is going to lay off personnel because
they
they
receive
taxes?
Yes, because they receive revenue from the.
Oh, I see. So it's a sharing agreement.
Absolutely.
And then the opposition was shaking his
I
head.
want to respectfully disagree with Senator Hall. The facts of the case, as went through with ALJ, is when the redevelopment agencies went away, these SkyTag billboards still had to advertise signs or businesses that were on site. Our biggest issue was that this company, and today you can drive by them today, as my counterpart did this morning, they're advertising something, a business that is not on site. They continue to break the law. And that's why they're coming forward today. A second point, the Highway Beautification Act doesn't have a dollar amount to it of losing your local transportation dollars. So if it's $1 million a month or $1 a month, it's irrelevant. They're blatantly violating the Highway Beautification Act. You guys are in jeopardy of losing 10% of your funds.
All right.
Thank you.
The same objection that my dear friend is making was the same objection that they made in 2013 when Senator Hill passed SB 684, 3 years ago. And no revenue was lost as a result of it. It was the same exact argument. And this honorable body passed it.
Other questions from members? The question I would have, the Lady Bird
And
Johnson.
by the way, this will expire in 2023.
The Lady Bird Johnson Act does indeed talk about losing 10% of the funds. That is a federal law. The question is, what is the federal government going to do about it? I think that's the issue. Okay, so there is a law out there, and let's put it this way. First Lady Johnson knew what she was doing, so when she put the penalty in there, because she wanted to make sure the law was going to be enforced, right? So she put that in the law when it was adopted, I think in the mid-'60s. So they identified these corridors, you can correct me if I'm wrong, they identified these corridors that were designated as part of the highway, scenic highway routes identified by the federal government. And those scenic routes have specified laws that have to be observed regarding outdoor advertising. Okay, that's the way the law basically works. We can get, might be interesting to get the committee copies of this law so you see what the law says. There was a recent, I think on the law, there was a recent administrative law judge decision regarding to Caltrans regulations. And these billboards are not the standard billboard. They are not, I wouldn't even describe them as billboards. They are way bigger than a regular billboard. So the question I would have is, why even involve other billboards which are much smaller in terms of square footage than these 25,000 to 30,000 square foot advertising display? These are not really what we consider billboards. These are 35,000 square feet. These are massive, gigantic display devices. So the question would be, how would we, if we can deal with these devices, these advertising devices separate from a billboard involving all the other billboards in California, that probably would be more appropriate. So the question would be, can you parse this in a way where it only addresses those two very large structures that generate a lot of money, way more than a typical billboard generates. And I guess that's why the city is quite concerned about this.
As to address one of the concerns, as identified in the analysis, if in fact there was a loss of revenue from the federal government to the state, the display owner would be required to remove the display and face a civil fine of $10,000 a day. That is to remedy any concerns if they should arise, which is the same concern, quite honestly, that was lifted by my dear friend 3 years ago when Senator Hill passed SB 684. So there is remedy should there be an issue as it relates to the loss of revenue.
Okay. I think the legislation needs work, I would say, unless it's limited to the two specific facilities.
It's my understanding, and listen, there are many other areas that have been adversely impacted by the loss of redevelopment or through their by loss of their redevelopment agencies. City of Compton, City of Inglewood, and others have seen just a city with great plans being destroyed as a result of this. Inglewood is one, Compton is another, and there are 98 other billboards in other communities throughout the state. think it would be a disservice to allow for one and not allow for other communities that are in dire straits. And finally, it is my understanding that it's the policy of this committee to not allow carve-outs for individual cities. And so then your request, Mr. Chair, to work with just Inglewood would not be applicable, because it's the policy of this committee to not carve out just for, I would love to do that just for anyone, but per the rules of this committee, such rules or such an allocation is not allowed. If you're saying, Mr. Chair, that it can be, I'd move that, but the committee rules say otherwise. These communities are hurting. Obviously, are the most distressed communities with redevelopment agencies, and here's another hit to our communities.
It's my opinion, if it's not carved out, then it's, I don't see a reason why the
Well,
drag.
can I ask?
I don't see any reason to drag 90 other billboards into.
I will ask this, Mr. Chair, with all due respect, I'll ask for there be a motion to waive the rule to allow of the committee, the standing rule of the committee, and allow for this particular body to vote to waive the rule and then vote on the carve out for Inglewood. I would accept that.
Okay,
Mr. Chair, if I may?
yes.
The policy you're about to take on right now would create, I think, a horrible standing and precedent for here in the state of California, what the senator, I believe, is asking you to do is to have an illegal sign. I can put it up, and you'll come create state law to grandfather it in. And so, a company like Outfront Media, who does things by the rules, we go get our local permits, we get our state permits, we get our federal permits that need it.
I understand.
What this is going to do is everyone's going to go put up these huge super graphics around the country, say there's no penalties, and say the precedence by the Transportation Committee is, we'll say, okay, now that's legal.
Mr. Chair.
We think it's a wrong
Excuse me,
precedent. Thank you.
Excuse me.
Yeah.
Senator has the floor.
Yes.
Okay.
Thank you. Thank you.
Senator Hall has the floor.
Thank you, Mr. Chair. I would ask that there be a motion to waive the committee rules to allow for the city of Inglewood then to be able to, for this bill to be applicable to the city of Inglewood, and then take the bill up.
Well, the reason why I raised the issue before about these are different is these are not really billboards. These are advertising displays that are of such magnitude. They're way over the size of a billboard that you might think of when you drive down a highway. These are massive signs that exist. Now, my understanding is that there's an agreement that they amortize out in how many years?
23.
So they have to be removed by 2023.
They've already been 3 years in, and they only have a few more years.
And then this helps amortize those signs by 2023, correct?
Correct.
Okay. I think that's acceptable myself. I mean, if we can have a motion on that. We have to move to waive the rule.
I move to waive the rule.
Okay, is there a second? Okay, we can call the roll.
Thank you.
The motion is to waive the rule. Senators Bell?
Aye.
Bell, aye. Canella?
Aye.
Canella, aye. Allen? Bates? Gaines? Galgiani? Galgiana, aye. Leyva? McGuire? McGuire, aye. Mendoza? Mendoza, aye. Roth? Roth, aye. Wachowski?
Six. You got enough votes? Six.
Okay, and then if we can take the bill up with that amendment.
This would be an amendment. Can you display the amendment, please?
Yes, the amendment would just, this bill will only be applicable to the city of Inglewood.
Okay, this is in the jurisdiction of the city of Inglewood.
Correct.
So moved.
Okay, any discussion? Okay,
I just want to make sure that, so, just to be clear, these billboards or these.
they're signs, I would call them advertising displays,
Right, will be,
electronic advertising
right,
displays.
by 2023, they'll be
All of them.
all gone.
All of them across the state, all 98 of them.
I thought this was only applicable to,
Oh, yes, but still, This is applicable only to Inglewood, but still all the billboards across the state will still be required to be dissolved
Now,
of.
there's a question here from one of the witnesses, Mr.
We've already addressed the witnesses in favor and against.
Senator, what would you like to?
I would like to.
Question somebody.
I just want to get clarification that it's something
Well,
different
they can
than the witness.
answer your questions if you.
Yeah, maybe the witness might have something that I'm not understanding.
Okay, go ahead, please.
Could I make a technical correction?
Yeah, go ahead. please.
The bill as existed said the signs are to come down in 2023, except there is a condition that Caltrans may allow the signs to remain for a longer period of time, contingent with the existing, or the pre-existing period that the redevelopment agency was authorized to exist. Now, I don't know what that means for these particular boards. It
don't
may be
have one.
2023, it might be 2040.
No redevelopment.
But there's just a very technical correction.
Okay, got it. There's no redevelopment anymore, so, correct?
That's correct.
Inglewood, okay. Okay. Do we have a motion? Any more questions? So we call the roll, please?
The motion is do pass as amended and re-refer to the Committee on Appropriation. Senators Bell?
Aye.
Bell, aye. Cannella? Aye. Cannella, aye. Allen? Bates? Gaines? Galgiani? Galgiani, aye. Leyva? McGuire? McGuire, aye. Mendoza? Mendoza, aye. Roth? Roth, aye. Wachowski?
Okay. We have 6 votes. We'll leave the roll open for other members. Thank you. Senator Cannella, I have to go to public safety. Okay. Can you go to the next item? I believe Senator Huff's next.
So Senator Huff. This is SB 1223.
Yes, it is.
Senator Frazier.
Thank you, Mr. President and members, or Mr. Chair, excuse me, I just gave you a promotion. Thank you for the opportunity to present SB 1223. Sitting by my side is Assemblymember Frazier, I'm proud to have as a principal co-author on this bill. He's been a champion on this issue, and I'm honored to have his expertise and experience to lend to the success. In 1997, the Brady-Jarrett Driver's Safety Act, authored by Senator Tim Leslie and signed by Governor Pete Wilson, established California's provisional driver license program. Since that time, this act has educated and prepared California's young, new drivers for the rules and trials on our road. Under current restrictions, during the first year of driving with a provisional driver's license, new drivers must be accompanied by a legally licensed adult 25 years of age or older when transporting passengers under 20 years of age at any time and driving between 11 p.m. and 5 a.m. California's provisional driver license program works and it saves lives. Since its implementation, it's resulted in a 40 to 60% reduction in teen fatalities. However, according to the California Department of Public Health and the Center for Disease Control and Prevention, vehicle crashes are still the leading cause of emergency room visits, hospitalization, and death for California children age 1 to 19 years old. Existing law allows drivers to obtain a full-fledged driver's license once they reach the age of 18. Research has shown that teens are simply opting to wait until their 18th birthday to obtain their driver's license, putting new drivers with zero behind-the-wheel experience on the road unrestricted and putting the lives of every driver, passenger, cyclist, and pedestrian at risk. To combat these alarming trends, a wide-reaching coalition of 70 stakeholders and groups launched the California Unintentional Invention Prevention Strategic Plan Project in 2013. SB 1223 is part of a larger package of bills authored by various members of the legislature to address these issues identified by the Strategic Plan Project. Current age of required participation in the provisional driver's license program is 15 and a half to 18. SB 1223 extends this requirement to all new drivers between the ages of 15 and a half to 21. Current exemptions for school, employment, medical necessity, and emancipated youth would also be extended for all new drivers between these ages. With that, and with the permission of the chair, I'd like to yield some of my time to Assemblymember Frazier, principal co-author of the bill.
Assemblymember.
Thank you, Mr. Chair and members, and thank you, Senator Huff, for graciously inviting me to co-author this bill with you. The issue of driver safety has been my paramount concern during my time in the Assembly. As Senator Huff has described, the emergency room statistics regarding young drivers are indeed staggering. As members of the committee may recall, I have tried numerous times to expand California's GDL program. SB 1223 takes a slightly different approach from my past efforts by requiring that young drivers, even those over the age of 18, are subject to a period of restrictions that gives them the time they need to learn the rules of the road and develop potentially life-saving experience in all kinds of driving scenarios. I'm optimistic that Senator Huff's thoughtful approach to this issue will allow us to be successful where previous efforts have not, and that as a state we are able to take on the epidemic of young driver casualties. Thank you, Mr. Chair, again, and members, and to Senator Huff for his leadership on this issue. A lot of the families in California do not want to be in my club. And with that, I would respectfully ask your eye vote.
Thank you. Other witnesses in support, if you could try to limit your testimony to 2 minutes, I would appreciate it. Thank you.
Good afternoon, Mr. Chair and members. My name is Kelly Browning. I'm the Executive Director with Impact Teen Drivers, a nonprofit organization dedicated to stopping the #1 killer of teens in America. I'm also here today as part of a larger statewide effort for the California Unintentional Injury Prevention Strategic Plan Project. Unintentional injuries are the leading cause of death and hospitalizations for California children and youth ages 0 to 19. Today's focus is on one of the project's top 10 issues, teen driver safety. Across California and the nation, Impact Teen Drivers works with first responders, health professionals, and educators to provide education on how to stop this #1 killer of teens in America. We provide specific strategies about what decisions and choices young people can make to help keep themselves safe behind the wheel, whether as a driver or passenger. An important part of our evidence-based program and curriculum is educating teens, parents, and others about graduated driver's licensing laws, or GDL laws. GDL involves a tiered system of licensing in which novice drivers gain experience before being exposed to the highest risk situations behind the wheel of a vehicle. GDL is an evidence-based strategy, and it's reduced teen driving fatalities by 40 to 60% across the United States. In a collaborative study done by the National Safety Council, the California DMV, and Impact Teen Drivers, we looked at a 9-year time period after GDL went into implementation in California. We took a 10% sample of all California licensed drivers. After looking at that, it clearly found that reduction in crash rates for California 18-year-olds versus those who did not go through the graduated driver's licensing program in our state. Additionally, this study reinforced why we want to extend graduated driver's licensing to those that are up to age 20. California novices drivers ages 18 to 20 have higher fatality and serious injury rates than all other age novice drivers, including 16 and 17-year-olds. California GDL laws clearly work. Teen drivers who successfully go through the GDL programs are 45% less likely to cause a crash than older novice teen drivers who are not covered by GDL. SB 1223 addresses this flaw in California's otherwise successful GDL law. California's current GDL program ends at age 18, leaving new teen drivers age 18 and 20 without the benefits of the graduated driver's licensing program. GDL does not prevent teens from getting a driver's license. The 3-step program allows new teen drivers to gain training and experience on the road while minimizing the highest risk driving situations. Exemptions already exist in the current law to allow the teens flexibility to attend school functions, work, medical, and help their families when other transportation modes are not available. I thank Senator Huff, Assemblymember Frazier, and Chu for their important and life-saving work on the issue of extending GDL for young novice drivers to make our roadways safer for really all of us, and respectfully, enthusiastically ask for an aye vote. Thank you.
All right, brief comments from other witnesses in support.
Thank you, Mr. Vice Chair and members. My name is Tom McGuire. I'm a current officer and 20-year veteran of the California Highway Patrol, but I come to you today as on the board of directors of the California Association of Highway Patrolmen, and we are co-sponsors of this legislation. I know for a fact of working the road for 20 years that this bill will save lives, reduce collisions, and reduce injuries. There's a common misnomer in the media that motor vehicles crashes are accidents. They are not. They are collisions. A collision means it's preventable, means that we can find a way to stop them. Education is the key here. This bill closes the loophole that Dr. Browning mentioned that currently allows young adults to skirt the educational requirements that are applied to the 18 and under group. We already know statistics show that this program works, and if we apply this law to the age group that currently is exhibiting the highest injury collision, accident, fatality rate of any other novice driving age group in the state. We work to save lives. I personally want to thank Senator Huff, Assembly Members Fraser and Chu, again, for sponsoring this life-saving bill. This bill will save lives, and I urge your aye vote. Thank you.
All right, other witnesses in support?
My name is Steve Barrow. I'm just here as the co-chair of the statewide California Unintentional Injury Strategic Plan Project. This is one of the top 10 issues identified by the 70 stakeholders in that project, and I'm just here to answer questions.
Thank you.
Kathy Barankin, Executive Director of the California Coalition for Children's Safety and Health, and also co-chair of the Unintentional Injury Prevention Project. As Mr. Barrow stated, here to answer questions, but strongly urge your support for this life-saving bill.
Thank you. Other witnesses in support?
Mr. Chair, members of the committee, Christy Bauma on behalf of the California Professional Firefighters, proud to be here in support.
Other witnesses in support? Witnesses in opposition? Seeing none, Senator Huff, I got a question. So the current provisional license, it says bars from driving between the hours of 11 p.m. to 5 a.m. or from transporting passengers who are under 20 years old unless accompanied by a provisional license holder, parent or guardian, and licensed driver 25 years old. And you want to extend that to 21, right? From 18 to 21. So what happens when, I mean, they're grown-ups at 18, right? They're off to college. So if a group of 20-year-olds are in college and they want to go grab something to eat, they can't ride together, and they have to have somebody 25 and older in the car with them?
If that's the driver, that's correct, because the whole purpose is public safety, not about social interaction. And there's plenty of people that do have their driver's licenses already, but the data is very specific that when they don't have the experience, they put themselves, their passengers, and other people at risk. So that's what we're aimed at.
So do the studies show that after 21, they have the required training and they're a lot safer at 21 and older?
I would let my experts here.
Okay.
Thank you for the question. The study actually showed that up in all ages of novices, regardless of age, those that hadn't gone through GL had higher crash rates and serious injury rates. There's a brain development that takes place in your early 20s, and it's after 21. That's also part of what is going to reduce crash rates. We know that there's a significant drop from like 22, 23.
Well, just because a lot of the criminal justice reforms that we've gone through, we show that it's up to 25. It's not 21. So I think if you pick 21 as just an age where we think it's going to be hard to hold them back at that point, because the science does show it's at 25.
Absolutely. The other piece of that is because of the climate of where we're at, and in an ideal world, it would be applicable to all ages, but that's not realistic today. So 21 is kind of the breaking point, just like you'd mentioned, they're adult. Same thing with the recent cigarette bill that passed, up to 21 being an adult. So we're trying to find a breaking point that's acceptable for everybody.
Yeah. I guess I'm just struggling with, this is going to be a big impact on a lot of folks, a lot of grown-ups that are over 18 years old, so I'm really struggling with this. So any other questions from the committee? Senator Leyva?
Thank you, Mr. Chair. Would siblings still be allowed to ride with each other even if they aren't 21, if you got a 17 and 18-year-old? Yes.
One of the exemptions.
Okay, thank you.
Other questions? Senator Galgiani?
I'm too struggling with this bill. I know what you're trying to do. In my district, we have a lot of rural communities where you can be out and not see any cars on the road for a long time, and this bill sets one standard for everybody regardless of where you live. I actually had a constituent connected with the Farm Bureau that was asking me to do legislation to go in the opposite direction, to allow some carve-outs for young people who are in farming families on ag land to be able to do things a little bit earlier. So I'm struggling with this one for that reason, that I can see it would definitely fit in the larger cities and with much higher traffic areas, but not so much in everyone's communities and all of mine.
Okay, other questions of committee? Senator Mendoza.
I just have so currently, anybody who has a provisional license is up to 18, right? If they started at 16 when they're able to get their license now, and they're provisional to 18, is that the current case right now?
No.
Okay, so when they get to 18, then?
If you don't mind.
Sure.
Current law says that you currently can get your driver's license as early as the age of 16. When you get your driver's license, you're provisional for a year.
Right.
So if you get your driver's license the day you're 16, you're provisional for 1 year until you're 17 years old. And during that provisional period of time, you're limited to those restrictions. Beyond that, you got your permanent driver's license. Now, the caveat to that is right now, when you turn 18, those provisions go away. So if I got my driver's license the day before I turned 18, I would be provisional for 1 day. And then I got my full driver's license. This bill basically extends that period up to the age of 21. So you would be provisional for a year. Upon completing your provisional period, you become a full licensee after that.
I understand. All right, so why don't they, so a year is not enough is what you're saying? You're saying that the age of 21 is more or less when you should be?
Well, because the first year of driving is the year of driving that these young adults do not drive safely. They drive distracted, they drive without their seatbelts on, they have their music on too high, they're talking to the people in their cars, and they're getting in collisions, hurting themselves and killing other people. So we found that after that first year that they had these restrictions, they've learned the rules, the laws, and then they're much safer drivers after that.
So why isn't the bill addressing that? Why isn't the bill saying where anybody who gets a license, they're provisional for a year, right, regardless if they're under 18 or not?
There's actually one state out of the 50 states that has that in place, and they're one of the few states that have had a continued reduction in their fatal crash rates and serious injury rates. I'm not opposed to that. That's just not what this bill says.
I mean, that sounds more reasonable than say all the way to 21. It just seems like, it's random. If someone's 20 and they just get their license for the first time ever, then a year provision after that would be, it's be expected. I mean, if you're 24, then, a year provision after that would be expected because you just have never been on the road officially with a license. But just to say you're from age 16 and you've been driving since 16, 17, 18, all the way to 21, provisional for 5 years, that's...
No, that's not what the bill is saying.
Just saying that you're provisional for 1 year up to the age of 21.
1 year period. So if you went down to apply, so this bill does not prevent people from getting their driver's license. What it's saying is if you wait till 20 or 19, we'll say 19, to
right.
go get your driver's license, you would be holding your provisional for 1 year.
Right.
If you get it at 16, you hold your provisional for 1 year.
Right.
At 17, you don't have a
But
provisional.
you don't go beyond 21.
Correct.
Okay, so I guess that's good clarification for me as well. So we're not going to make them be in a provisional.
No.
It's just if they're 20 and they get a license, it's 1 year to 21.
Correct.
It's still, everything else applies.
My apologies for not being more clear. Additionally, one of the reasons the question of coming up to 21 is that the data was clear in the California DMV study showing that was the 18, 19, and 20-year-olds had the most serious fatality and serious injury rates above any other age group. So that was kind of a breaking
We're going
point.
to be clear, if they get it at 16, they lose their provisional at 17, even under this law. 17,
That's
it's 18, 18, it's 19, 19, it's 20, and so on and so forth.
It's simply extending.
Still just a 1 year provisional.
correct.
Okay,
Sorry.
that's much better.
25.
Okay. Yes, sir.
I just wanted to answer Senator Galgiani's question. I represent 44 rural counties. That's where I do most of my work in underserved communities. The crash, death, fatality, and hospitalization rate for teens in those counties is higher than the urban. And so it is something of great concern to us that it's a misnomer. I was a farm kid, and I grew up driving since I was 14 on the farm, hauling hay and stuff. But getting on a road is a whole different ballgame. The crash rate in a lot of our rural areas is higher, significantly higher for our teen drivers. And so I just think I would think about that.
All right, thank you. Any other questions of the committee? All right, would you like to close, Senator Huff?
Yes, thank you, Mr. Chair and members. And I think the questions are good to help answer evidently questions that we didn't, address in our entry, but our opening. But the reality is, it's evidence-based, it's data-based. We will save lives, and I would ask for your aye vote.
Okay. I'm sorry? Nobody's moved the bill yet. So we have a motion from, well, we have a motion by Senator Mendoza and a second by Senator Wajkowski. So we have the secretary call the roll.
The motion is do pass and re-refer to the Committee on Appropriations. Senator Escanella?
Aye.
Senator Canella, aye. Allen? Bates? Gaines? Gaines, aye. Galgiani? Leyva? Leyva, aye. McGuire? McGuire, aye. Mendoza? Mendoza, aye. Roth? Roth, aye. Wachowski? Wachowski, aye.
Right. Thank you, Mr.
Thank you very much.